fifth case from the list for final resort item 1, first appeal 43 of 2012.
The last appeal, the respondent number 16 to 18 said that they will also be arguing. Then your lordship said that let them, for 10 minutes I will give the consolidated reply. Otherwise,
where are they?
But I am appealing for 16 to 18.
And there is one
Lordship said not. Your lordship will give me 10 minutes of hearing only. Because I have prepared a short compilation of what I need to argue, along with the judgments on which I am doing. Nothing more. I have given the copy notes to both sides.
Place yours, whatever you have to.
Yes.
What is this? ना क्या बोलना है आपको?
But हमको खाली limited note में 4 points पे submission. This is because we have been impleaded parties during pendency of the appeal. We are claiming our rights through Paul. But I only want to bring those facts to your lordships. Nothing more. And how not what has happened during pendency of the litigation, and those are recorded in the judicial orders passed in this proceeding also.
By which order were you impleaded?
Yes. But I was impleaded by order dated 5/10/2012.
All three.
Yes, 16, 17, 18.
16,
17, 18.
17, 18.
Yes.
Order dated
5/10/2012. Order number 15.
5, 10,
2012.
2000.
But we are claiming our right through Paul's on basis of an agreement which culminated into a title suit. That is title suit number.
All the three.
All the three. Title suit number is 92 of 2010.
Then
In that title suit, the compromise petition was filed between the plaintiff of that suit, that is us, and the Pauls through their power of attorney. That is Tarun Kanti Ghoshal.
it ultimately ended in a
And
compromise.
ended in a compromise, but the compromise date is 25/6/2011. This is the compromise
25/6/2011.
This is the compromise decree. So now, we on basis of which we were implemented. Now, after this order, the lordship may kindly take the compilation which I have given your lordship.
No, this
that-
order,
Yes.
this order is a conditional order.
Sorry, notes?
It has got some conditions.
No, it is not. It is not conditional.
Let us have a look at
Yes.
the order. 5/10/2012.
Yes. But I have annexed that order also.
Okay, let's see
That
that.
is at page 15.
At page 15.
Yes. 5, 10, 12 minutes.
Moreover, learned counsel for the applicant interveners have made it clear that they will not try to cause any delay in the hearing and confine their arguments
Yes.
to safeguard the interest in respect of the properties claimed by them on
Yes.
the basis of compromise.
Yes. So this is my interest that I am protecting my interest which have been accrued to me on the basis of a compromise in the year 2011. Now, after this order, the lordship may kindly turn to the next page, This is page number 20 of the compilation. This is order dated 23/3/2012. Your lordship may kindly make a note of this. 3/2012. Yes. But here, an application was filed, and I am just placing, taking all these facts and circumstances into consideration, which I have marked from the red pen. I am of the view that since the appeal is admitted, respondent shall maintain status quo. Meanwhile, the authority shall ensure compliance with the interim orders. So, but this is the date on which the status quo order was passed. That is 23/3/2012. So, March 2012, an order of status quo was passed. Now, your lordship may kindly take note, page number 27. Note basically memorandum of understanding. The date is 31st March 2012. That is after the status quo order. Because 23rd March is the status quo order. It is 31st of March 2012. And kindly take notes 2 pages next. Page 2, page 20.
This is not a part of the record.
Sorry, notes?
This is not a part of the record.
No, I am just placing the fact because this has come. I will just show.
Where is it in the
Sorry,
record?
Lord. No,
Where is
this
it
has
in
come
the
in the
record?
order itself, judicial order itself. It is there.
Where is that? In which order it is?
Yes. But your Lordship wants to see about this memorandum.
Yes, I want to know. Where is it?
But-
Where is it in the records?
But that is not exhibited because this is 2012.
No, maybe. But at least there should be some document mentioning about this.
But I
How
only
will I put this particular document in my order?
no, Lord, I only want to show that Lord, so far as
Show me by which order this particular memorandum of understanding has been recorded, that there is a memorandum of understanding.
there is a memorandum of understanding.
Where is, which order is that? In which order it is recorded that there is a memorandum of understanding and there is a violation of the order of the court? Where is that?
No, Lord, I am only yes, that I will show. That I will show. The Lordship may kindly take the judicial order itself, Lord, page 21. That is 17/1/2013,
Yes, page 21.
page 21.
Yes.
Yes, but let me just place this order. But this an IA, Lord, IA number 1554 of 2012.
Who filed this IA?
Yes, Lord. This
Who
is an
filed this
application
IA?
filed by the plaintiff, Lord.
Yes.
The plaintiff, Lord, the Pauls filed an application for vacating the status quo order,
That's right.
which was passed in March 2012. This was filed by them, and your Lordship may kindly take the next page. What is the court's order? At this stage, I am reading notes paragraph 2. At this stage, the learned counsel for the defendant appellant has submitted that during pendency of the appeal, the plaintiff respondent has sold part of the property in question. It is further submitted that the plaintiff has not sought any permission from the court to sell the property during pendency of the appeal, and the property was sold in gross violation of the order of status quo. Therefore, the sale is hit by principles of respondents. The appellant have already moved against the plaintiff respondent under the Contempt of Courts Act. Therefore, the sale made during pendency of the litigation must be declared null and void. I find force in the submission of the learned counsel for the appellant that the sale made during pendency of a litigation is barred by principles of respondents and is in violation of the order of status quo. However, the legal status of the sale in question shall be decided while deciding the appeal. So, Lord, why I am showing this to your Lordship is 23rd 3/2012 versus status quo order. The sale deed of the respondent number 19 is all after this. There are total 10 sale deeds, Lord. 9 sale deed is dated 23/7/2012, that is in violation of status quo order, and 1 sale deed is 27/7/2012. And therefore, this observation was made by the court. And your Lordship may kindly flip to the next page, where Lord, we filed an application. That is page 23. This order was passed on their application by the courts and for vacating, and now Lord, and IA number 3244 of 2012, while order dated 5/10/2012, respondent number 16 to 18 were directed to be impleaded as party respondent. The present application has been filed by the newly impleaded party respondent for a direction that the sale deed executed by respondent number 1 so and so during pendency of the appeal may be declared as null and void. In the considered opinion of this court, the applicant newly impleaded respondent number 16 to 18 were not party before the trial court. Moreover, an application under order 39.2a to CPC to declare the said transaction null and void is not maintainable. Validity of the sale deed can be seen while deciding the appeal filing. So this was the observation. So now, notes, I am only trying to show that, notes, in the year 2011, by virtue of a compromise decree through Paul's, notes, the right of Paul was transferred in my favor by virtue of a compromise decree in that suit. That, notes, suit is pending now in under section 28(1) for execution of the decree in terms of the compromise. Now, notes, in the status quo order passed by this court on March 2012, the sale deeds by which, notes, respondent number 19 is claiming is all after during pendency of the status quo order, and in
Respondent number 19.
respondent number 19, not mine, because
Don't argue about respondent number 19.
no, I have to protect my interest also.
It should be sufficient to say that after this, that whatever be the result of the case, suppose the appellant wins the case,
Yes,
right?
yes,
आपका कहानी खत्म?
yes, ma'am.
पूरा?
Yes,
Totally?
totally. If the Paul fails, we fail.
If the Paul fails, you fail.
Yes, ma'am.
So story is over.
Yes,
If they lose,
yes,
right? Then everything, whatever happens
Yes.
during the pendency of the case has to be subject to this pendency. इसके लिए इतना सोचने समझने इसकी क्या जरूरत है?
It has to be in respondent's note, but coupled with the fact that whatever right respondent number 19 is claiming is in violation of a status quo order passed in these
You see,
proceedings.
whatever.
Yes,
You see, even if there is all the orders are at the interim stages,
Yes.
right?
Yes.
And every order has to merge with the final order.
Yes.
There is no doubt on that.
Yes.
If the Pauls wins, right?
Yes.
Then there could be, even if the Paul wins,
Yes.
then you will have your right accordingly.
Yes, we will have.
We are not going to adjudicate the dispute between two court respondents in this case.
Correct, absolutely.
We will
Now,
not decide that.
my only prayer is that whatever my submission is, it is bearing from the records. And why I say this, because there are judicial orders which have not been challenged. That what will be the validity of a sale deed which
I
have
will
been.
also see.
Yes,
I will also see my jurisdiction in
Yes.
the first appellate
Yes,
court.
yes,
Merely
definitely.
because there is an observation, it will be seen at the.
No.
Even those sale deeds do not form a part of the record.
But I only.
Even those sale deeds in
Yes.
in connection with which you want me to pronounce.
No, I don't want your lordship to pronounce
Then-
anything. I only want to just show to your lordship what is the conduct of respondent number 19 and how they have been impleaded. Therefore, there was a rider of Thompson Price judgment. Your lordship, I have annexed that. And I want to only show to your lordship one judgment which shows that what should be the right of the court and what should be the power of the court. If some person, let me assume here, that respondent number 19 is in violation of a status quo order, have purchased a suit property, have been impleaded with a rider.
Registry has been done.
Yes, registry has been done.
When?
But this is all after
When?
2012.
This is a registered document.
Sorry, what?
This is a registered document, 27.
Yes, yes.
This memorandum of
No,
understanding.
not memorandum, not sale deed.
Where is the sale deed?
They are claiming to 10 sale deeds.
Where is
on
the
basis.
sale deed?
Sorry, what?
Where is the sale deed?
But they are.
नहीं है, कहीं कुछ नहीं है.
हम ये नहीं बोल रहे, हम ये नहीं बोल रहे, because the suit is already pending. I only
You
want to
see,
show.
only thing I want to observe
Yes.
that inter se dispute between the interveners
Yes.
cannot be decided in this
Yes.
particular suit.
Now, Lord, your lordship will.
इसके अलावा आपको
No.
कुछ बोलने की
Lord-
जरूरत नहीं है. ये जो ऑर्डर आप बोले हैं हम अपने जजमेंट में सब डाल देंगे.
Lord,
मैं बात
your
कर
lordship will also not see that if a party has violated an order of a court, will the court shut his eyes?
Contempt will take
No,
care.
will the court shut his eyes, Lord?
We are
Because
not,
we filed
you
an
see-
application for contempt.
You see, these are very intricate questions,
Yes, ma'am.
right? Of adjudication as to what will happen to an order of violation of an order of status quo, what will happen ultimately, because all the interim orders are going to merge with the final order.
So your lordship will definitely should observe, not that there are sale deeds which has happened in violation of a status quo order, and what will be the effect because
Status quo order will merge finally.
it will merge
with the
finally.
judgment.
So not
Yes.
if any
And all the
transaction,
consequences will follow.
yes, if any transaction has held during pendency of a status quo order, Lord, your lordship may kindly take note. I have annexed one judgment 95 S6 ACC
If
page
there is
50.
if there is any violation of status quo order,
Yes, ma'am.
then under such circumstances that will be a subject matter of another suit.
Yes, that is
Where-
subject matter of another suit.
Where you will challenge that this particular, even if Pauls had title,
Yes, Lord.
even if everything was fair, even if you have title,
Yes.
then also that particular status quo order, what will be the consequence of that status quo order in civil litigation is something which is a matter of, you see, any pronouncement over here with regard to any of the sale deeds which do not form a part of the record, we will not
Lord,
pronounce anything.
therefore I said,
Because
Lord,
there could
that-
be a sale deed which says that it is subject to the result of the case. There can be a sale
Yes,
deed.
there can be a sale deed.
There can be a
But
sale deed.
subject to result of a case is depending upon either party is winning and
There
party
can
is
be
claiming to it.
there are sale deeds which says that this sale deed is being executed subject to a result of
Yes, yes, there can be. But here, Lord, the question is somewhat different, is that it has been executed during pendency of a status quo order, and therefore, Lord, I want to show only one judgment or one paragraph of this judgment. Your Lordship may kindly take note 95 6 ACC page 50 in my compilation. Lord, this was Lord second flag blue on top, Lord, second flag. 95 6 ACC page 15, Lord. Sujit Singh versus Harban Singh. Have you Lordship? Lord, kindly take note paragraph 4. Here also, Lord, in defiance of a restraint order, there was allegation. What the court says, Lord, let me place paragraph 4.
We will not read right from paragraph 4, we will
Yes.
read from paragraph 1. What was the
Yes.
cause of action?
Yes, yes. May I please? Here is an unfortunate dispute between members of family, the head of which was one Janak Singh. It appears that Janak Singh had no son, but had a daughter, who on marriage has been given birth to 3 sons, namely Gurdayal, Jeevan and Preetham. Janak Singh appears to have adopted Gurdayal Singh as son. He has considerable house and landed property, and since the property divides, the members of the family got to be litigating with each other. With all sincerity and in putting an end to it, Janak Singh and Gurdayal Singh, Jeevan Singh and Preetham Singh executed a family settlement deed on 27/6/1930, which was registered in the office of the Sub-Registrar Patiala. A broad feature of that settlement was that all the four recognized each other as co-sharer of the properties, and Janak Singh under the settlement, and it was contemplated that on the death of Janak Singh, his fourth share would devolve upon the remaining 3 co-sharers. Prima facie, the aspiration embodied in paras 13 and 14 thereof discloses that alienation of the property during lifetime of Janak Singh was prohibited with consent of other, and the property was meant to be preserved from generation to generation within the family. On the demise of Janak Singh, the suit for partition for separate possession of property was filed in the year 1948 by Jeevan Singh and Preetham Singh against Gurdayal Singh. A preliminary decree was passed by the subject at Patiala on 7/4/50. While proceeding for passing final decree were pending, parties moved for accounting and preservation of men's profit. On 29/7/77, the trial court passed an order of restraint, meaning all the parties from alienating or otherwise transferring in any manner any right in the property involved in the suit. It appears that Preetham Singh assigned his right under the preliminary decree on 6/6/79 by a registered deed, partly in favour of his wife, of his lawyer, Sri Ram Singh Saluja, advocate, and partly in favour of others, in the teeth of a restraint order of the trial. On the basis of the said assignment, the assignee made an application under Order 22 Rule 10 CPC requiring the trial court to permit their impleadment as parties to the proceeding of the suit. Since they were aware that the claim of the impleadment was precarious on account of existence of restraint order, they indulged therefore in legalistics and projecting that the assignment of a decree cannot be confused to be a transfer or alienation of the property, and that the decree was barely a paper and which has been assigned. They tried to interpret para 13 and 14 of the settlement deed to be saying that the grandson of Janak Singh, Preetham Singh, being the daughter and son of Janak Singh, could not be bound forever to be not alienating his share of the properties to the stranger. The trial court granted the prayer of the assignee. The appeal of Gurdayal Singh and Jeevan Singh, plaintiff before the additional district judge, failed on both counts, and High Court dismissed the revision petition in limine, which was given the cause of action for them to appeal this court. We could have arrived at the conclusion which we are about to by reading on 2 different parts. One was the way in which the trial court and the additional district judge have been led in pronouncing on the 2 contentions raised as to the nature of assignment of a decree being property or not, and the interpretation of para 13 and 14 of the settlement deed. The other was in treating the assignment as knowledge because of the clear prohibition of the trial court to the parties from alienating or transferring in any manner or any part of the property involved in the suit. Having heard learned counsel for the parties at great length and having examined the settlement deed as also the assignment, we are of the view that it would be more prudent to treat the second part and to arrive at the conclusion laying that the matter back to the trial court for finalization of the suit by passing a final decree in partition. As said before, the assignment is made by means of a registered deed. The assignment has taken place after passing of a preliminary decree in which Preetham Singh have been allotted 1/3 share. His right to the property to the extent stood established. A decree relating to immovable property worth more than 100 rupees is being assigned was required to be registered. That in the instantly been done. It is per se property, for it relates to the immovable property involved in the suit. It clearly and squarely fell within the ambit of the restraint order. In sum, it did not make any appreciable difference whether property per se had been alienated or a decree pertaining to that property. In defiance of a restraint order, I am emphasizing on this, in defiance of a restraint order, the alienation assignment was made. If we were to let it go as such, it would defeat the ends of a justice and prevalent public policy. When the court intends a particular state of affairs to exist while it is in session of a list, the state of affairs is not only required to be maintained, but it is presumed to exist till the court orders otherwise. If the court in these circumstances has the duty as also the right to treat the alienation public assignment as having not taken place for all its purpose. Once that is so, So only this part I want to show. That not it is the Supreme Court says that it is for the prevalent public policy the court intends to have any particular state of affair at one point of time, and in defiance of anything, the court's order, if anything have happened, the court should take it to the same state and treat it the alienation have not taken place for all purposes. And on this note, and on this principle only, other two judgments are there, which shows that if anything have been done in violation of a status quo order or a restraint order, that should not take the courts, and the court should make sure it is not, the language is not, when the court intends a particular thing, affair to exist in a list, in a session of a list, that the state of affair is not only required to be maintained, but it is presumed to exist, the court order. The court in these circumstances has the duty.
You want, what is the relationship between you and respondent number 19?
But there is no relationship. There is no relationship. I only want to show to your lordship that how respondent number 19 has, in violation of a status quo order, has purchased through the same power of attorney holder.
The same property.
Yes, same property.
Your property.
Say my property. That is what. Because your lordship will see, I have claiming the right on basis of a compromise decree.
From where do I get this?
Sorry, Lord?
That the same property has been purchased by him. Show me some pleading, some document, some record.
About that it is same property.
How do I know? Show me something from the record that is the same property. The sale deeds are not there on record.
Yes,
We do not know which property is he claiming. By which order he was made party.
yes, that is also alleged.
And at
This
whose
is-
instance he was made party? He was an intervener.
He was an interview.
Neither the sale deeds are there, nor the description of property which you have purchased is there. How do I give a finding that his sale deed is
But-
null and void?
Therefore, those orders which I placed was there, that just to show that whatever transaction the Pauls have done in violation of a status quo, therefore, this is page 24 by the order by which respondent number 19 have been implemented. 14/12/2018.
Yes.
May I place? Yes, in the interlocutory application have been filed under order 1/10 CPC for impleading Bhavesh Commodate to its director Piloki Singh having its registered office so and so as party respondent in the appeal. Learned counsel for the applicant has submitted that during pendency of the present appeal, the applicant has purchased the suit property in question, while 10 registered sale deed executed between 23/7/12 and 27/7/12. It is submitted that the applicant has expended a substantial amount of 24 crores for purchase of land. That if the applicant is not included as a party in the present appeal, he shall suffer serious loss and irreparable and injury as the adjudication of the involved issue and the decision likely to be rendered therein will have direct and substantial bearing on the interest of the present applicant. Learned counsel has relied upon a decision of so and so. Learned counsel appearing on behalf of respondent number 1 to 9 and respondent number 16 to 18, though have not raised any objection, but submitted that the applicant has purchased the suit property through registered sale deed after passing of the status quo order on 23/3/2012. That a compromise decree was passed in title suit number 92 on 16/6/11 and hence the question of title is in dispute. Submitted that the fact that the applicant has purchased the suit property from the power of attorney holder who has no authority to sell the suit property in view of the compromise decree. It is submitted that the suit have been filed challenging the sale deed is executed by the power of attorney holder in favor of the applicant. It is submitted that there is no objection if the applicant is included as party in the present appeal on the condition that he shall take only such defence which are available to the original owner. Third, it is well settled the position of law that the doctrine of least pendants is founded on the principle that for administration of justice, the decision of a court or suit of appeal should be binding on not only to the parties litigating parties, but also on those who derive title pendent right. Section 52 of Transfer of Property Act as 1882 does not annul pendent right transfer or render it void, but it makes it subservient to the rights of the parties to the litigation. And in view of Thompson Press, in paragraph 5, he has been implemented. This your lordship will have seen that this observation was there that they have violated the status quo order, there was a
आगे भी
time.
देखिए ना, subject
Yes.
to the writer that the applicant will be entitled to pursue such defence as were available to the original owner.
Yes,
That is the pulse.
that is the false.
Whatever is available to the original owner only, that will be available, nothing
Yes,
more.
yes.
So how do I decide the dispute between both of you?
No.
Neither the power of attorney is before us,
Yes.
right? Nor the sale deeds are before us, nor any of the deeds entered into between the parties are before us, nor the details of the parties are of the suit property is before us.
Yes.
So how do I
No,
decide?
Lord, I am only trying to show to your lordship
That
this
you have,
only
you have seen.
that
You see, here we will
Yes.
decide only that dispute,
Yes.
which is between the plaintiffs and the defendants, and there is no question of deciding any dispute interest.
so Lord, I am only adding one.
I will just keep it open.
Yes.
You can fight it out wherever you want to.
Yes.
If there is a violation of the
So
order,
your lordship will also take notes into account if something has happened in violation of a proceeding.
how do I come to know? How do I come to this finding that there has been a violation? Because the sale deeds are not on record.
No, Lord, because it is their application which says that this is
Maybe
my
that
sale deed.
will not-
This is the date of my sale deed.
That will not decide everything. The terms and conditions of the sale deeds are also equally important.
So, Lord, let me assume that there is a status quo order, but whatever terms may be in
We
the
do
sale
not
deed,
know.
whether it can override that status quo order. No, Lord.
Can we set aside the sale deed
No,
over
I'm
here?
not
It is
saying
not
that.
even on
I'm not
record.
saying that. I'm
Then-
not saying that. Lord, once a suit has been filed by Pauls against respondent number 19.
You see, the whatever is the number of sale deeds has been executed during the pendency of this case.
Yes.
The purchasers are there before us. If there is any litigation which arises between co-purchasers, they will settle it through a different litigation. We are not going to adjudicate
Lord,
this.
I am only on this. Lord,
No,
I,
that is an issue before
I
us.
know your lordship's limitation under section 96, but I am only trying to show to your lordship only this, nothing more than that. That if there is any restraint order, and if a party violates that order, but the court will not shut his eyes. The court will have to not say anything on that. That if what will be the effect, then Lord, if the court passes an injunction order or the status order or whatever kind of stay order, and if party claim goes on executing, violating that, but the court will not close its eyes and say that will be decided in a
Those
separate
sale
suit.
deeds are not before us. We do not know which portion of the property has been sold.
But if the status quo order is on the entire suit property, they have purchased. Let me assume they have purchased part of the suit property. Then also there is violation of status quo order. It can't be said, okay, since I have not purchased the entire property, I have not violated the status. But my only argument is this, that if they have purchased in violation of a status order, your lordship will keep in mind that if a party violates the order of a court, he cannot be left like this. That your dispute will be adjudicated.
Who is
Your
their
lordship.
vendor? Who is their vendor?
Their vendor is same person, Lord Power of Attorney of Paul Tarun Kanti Ghoshal, who has entered in a compromise with me in the year 2011, who they are aware about the pendency of the litigation, that is the present proceedings, because all the MOUs, which I just wanted to show only for this purpose, that they were aware of this fact, that there is a litigation, there is a compromise decree in this property. In spite of this,
Is that power of attorney holder a party before
No.
this? He is not party
He is
before
not
us.
party, yes.
Therefore, what is the consequence of list pendants?
But-
There are two persons.
Yes.
One is the owner of the property, and the other is his power of attorney.
Yes.
Power of attorney, as such, is not a party before this court.
Yes.
Right? He is executing many things. We do
But
not
he is
know.
executing on basis of power.
Maybe.
Yes.
But that power does not stand suspended, and that particular power of attorney is not before us.
But I am saying this, that once the power of attorney holder, if your lordship also sees this, that once the power of attorney holder, let me assume this, that he enters into a compromise decree with me, the power ceases on that day, because whatever power Paul has given with respect to the suit property came to an end on basis of a compromise in that suit.
So therefore, section 54 क्या कौन सा है? Then if there are two sale deeds, the previous one will prevail.
Previous one will prevail, definitely. So your lordship will
So
only.
that will be adjudicated only in a suit between both of you,
Lord, it is,
not in this proceeding.
no, Lord, I am saying this, that if anything has been done, I agree to your lordship, Lord, on this, that if there are two sale deeds, one after another, say 1 year or 3 years or whatever time it may, whichever is earlier, that will prevail, that will have a right first. Definitely not. There is no dispute on this. The only point I am trying to emphasize is that if a sale deed have been executed in violation of a status quo order passed by this court, and they being aware of this
You
fact.
see,
Yes.
if the entire property was already sold to you,
Yes.
then under such circumstances there was no property to be sold.
I am
So
saying-
therefore there is no
Yes.
violation of status quo order.
Not because the sale deed have been
Because,
executed.
just a moment,
Yes.
the entire property has been sold to
It
you.
is not sold. It is a decree. It is a
Decree,
compromise.
whatever it
Yes.
is,
It
you
a compromise.
acquired a right.
Yeah, I acquired a right.
You acquired full right over
Yes,
the property,
yes.
right? And the Pauls were divested of that right,
Absolutely.
right? Nothing was left to the Pauls to be sold.
Yes.
If there is a sale deed, where is the violation of status quo order? There is no violation of
Therefore,
status quo
Lord,
order.
in my submissions,
If there are repeated sale deeds being done with respect to a property which has already been sold to you,
which is already Lord,
which is
it a
already
compromise
sold.
decree. It
Yes,
has been
whatever, sold,
a
compromise,
decree has been
whatever.
passed.
Yes, a decree has been passed.
Therefore, exactly, Lord, this is my submission. Your Lordship may kindly take note. Page 8 of my submission.
आप एकदम unnecessary
यही-
टाइम वेस्ट कर
मेरा
रहे हैं,
यही
इसका कोई
सबमिशन ही
मतलब
है,
नहीं।
Lord. I have
आप लोगों का आपस का डिस्प्यूट जो रिकॉर्ड पर नहीं है उसके बेसिस पर हम सिर्फ ऑर्डर्स के बेसिस पर आपका इंटर से पार्टी का डिस्प्यूट हम नहीं डिसाइड कर
हम
सकते।
इंटर से पार्टीज का डिस्प्यूट नहीं बोल
फिर
रहे।
क्या बोल रहे हैं?
हम खाली इतना बोल रहे हैं कि इनका जो सेल डीड हुआ है which is in violation of
हम
status
नहीं
order,
जानते।
बस
हमें तो यही नहीं पता इनका कौन सा प्रॉपर्टी का सेल डीड हुआ है।
but suit property है.
आपको क्या
Whether it
पता?
is part
We
of
do not know unless we see the sale deed. We will not say anything.
but
That sale deed is not before us to find out. अभी तो सूट प्रॉपर्टी का आइडेंटिटी को लेके इतना लड़ाई है।
not whatever this
नहीं, अभी तो सूट प्रॉपर्टी को आइडेंटिटी को लेके इतना लड़ाई है। अभी यही नहीं पता है कि मतलब which is the suit property, which was the property which was auctioned. Everything is in a fluid state. How do I find out that इनका कौन सा प्रॉपर्टी बेचे हैं?
not
जो सेल डीड मेरे पास नहीं है उसके ऊपर हम कुछ भी
हम वो नहीं हम लोग कहाँ बोल रहे हैं कि योर लॉर्डशिप विल एडजुडिकेट कि हाँ सेल डीड वो हम खाली इतना बोल रहे हैं कि योर लॉर्डशिप विल
आपका जितना ऑर्डर है
हाँ
आपका जितना ऑर्डर है वो हम लिख देंगे
हाँ।
और हम इतना लिख देंगे कि एक भी डॉक्यूमेंट मेरे पास नहीं है
हाँ,
तो
लेकिन
now
वो
send
नहीं
to one.
Lord, खाली ये जो है कि what जो impleadment का बात हुआ है या जो भी है जिसमें पार्टीज बने हैं हम लोग या ये बने और जो स्टेटस को ऑर्डर था एंड इनका सेल डीड क्योंकि इनके ऑर्डर में एकदम आया है कि ये इनका सेल डीड
ऑर्डर से सेल डीड नहीं बनता है
नहीं।
सेल डीड से ऑर्डर बनता है
हाँ वही तो बोल रहा
ठीक है
हूँ इनका जो
जब
impleadment हुआ
बेसिक
है
डॉक्यूमेंट मेरे पास नहीं है
हाँ
तो उस सेल के बारे में हम क्या प्रोनाउंस कर सकते
हम
हैं
कहाँ बोल रहे हैं लॉर्ड प्रोनाउंस कर हम तो खाली ये बोल रहे हैं कि एनीथिंग व्हिच हैज बीन डन इन वायलेशन ऑफ अ स्टेटस कोड एटलीस्ट योर लॉर्डशिप विल ऑब्जर्व
I will see whatever
yes because that finds mentioned in their impleadment order also I am only saying this nothing more lord
आप
and
लोग के कंसेंट से तो कोई ऑर्डर नहीं होगा
कहाँ
ठीक है उन्होंने बोला उस समय इंटरलोक्यूटरी स्टेज में कोर्ट ने कुछ ऑब्जर्व किया
हाँ।
इतना ना तो मैचिंग होता है उस स्टेज में और जब हम फाइनल स्टेज में आपसे सेल डीड खोज रहे हैं तो सेल डीड रिकॉर्ड पर नहीं है तो हम क्या यहाँ पे प्रोनाउंस करेंगे
हम कहाँ बोल रहे हैं लॉर्ड सेल डीड हम कहाँ बोल रहे हैं कि आप योर लॉर्डशिप विल होल्ड कि सेल डीड एग्जीक्यूटेड इन फेवर ऑफ नंबर
यही तो आप
90
बोल रहे हैं डायरेक्टली इनडायरेक्टली और
नहीं
क्या बोल रहे
हम इनडायरेक्ट हम लॉर्ड खाली डायरेक्टली इतना बोलना चाह रहे हैं कि व्हाटएवर सेल डीड दे आर क्लेमिंग is in violation of status order nothing
हैं
more I
whatever
want.
sale deed we do not know which sale deed they are claiming
there are-
we do not know whether that sale deed is a part of the suit property or not because we are not clear about the suit property also
But that your lordship will see on your lordship will finally decides the matter. But here, Lord, if their impleadment says that I have purchased the suit property on such and such date, that is on 7th month of
now you
2010.
answer one thing
Yes.
when you say that the entire suit property was already purchased by you, there was nothing left to be sold.
Your lordship will observe this in my submission only.
हम आपके सबमिशन में कुछ भी नहीं है समझ
क्योंकि मेरा जो submission है, your lordship will at least record that.
आपका तो रिकॉर्ड हम करेंगे ही रिजेक्ट करने के लिए
ठीक है, रिजेक्ट कर दीजिए, Lord, हम कहाँ बोल- लेकिन मेरा submission क्योंकि whatever I am saying is not Lord out of the record.
ठीक है द लर्नर काउंसिल एक पे इनका अलग से सबमिशन लिखिएगा ऑन बिहाफ ऑफ रिस्पॉन्ड नंबर 16, 17 and 18 has submitted that that they were impleaded as party in this case by on account of intervention by order dated 5/10/2012 primarily on the ground that they were in litigating terms with Pauls in title suit number 92 of 2010, which ended in compromise on 25/6/2011, and therefore the respondent number 16, 17, therefore the interveners who subsequently became respondent number 16, 17 and 18 acquired the entire property. He has also submitted that on 23/3/2012, an order of status quo was passed There is 23/3/2012.
So page 20.
An order of status quo was passed wherein the respondents were directed to maintain status quo. He further submits that later on the power of attorney of the plaintiffs, he entered into a sale deed
Yes.
with respect to the same property with respondent number 19. And respondent number 19 became a party to the proceedings on 17/1/2013.
No, not on 17 one, but this is on 14/12/2018,
On 14/12/2018,
page 24.
after the passing of the status quo order. He has submitted that subsequently on 17/1/2013 it was observed by this court the argument of the appellants was accepted by this court that sale made during the pendency of the litigation is barred by principle of lis pendens and was in violation of the order of status quo. It was also observed that the legal status of sale in question shall be decided by deciding the appeal. The learned counsel submits that further observation was made that validity of sale deed can be seen by deciding the appeal finally. The learned counsel has referred to judgment passed by the Honorable Supreme Court reported in bracket 1995 bracket pro 6 SCC 50 and has submitted that in the said case also the sale deed was in the teeth of status quo order and it was held that the principles of lis pendens are altogether on a different footing. Right?
Yes.
He has submitted that the sale deed executed after the order of status quo cannot be sustained in the eyes of law. However, during the course of hearing, he has fairly submitted that neither the compromise decree is on record, which is said to have been passed in title suit number 92 of 2010, nor the sale deed, one or the other sale deed claimed by respondent number 16, 17, 18 and 19 are on record, nor the power of attorney of the plaintiffs are party in the present proceedings. Correct?
But we'll see not record exhibit नहीं क्योंकि they were not exhibited क्योंकि these are क्योंकि impleadment में हम लोग अगर फाइल किए हैं because I was not
I do not know आपने क्या फाइल किया क्या फाइल
क्योंकि impleadment में वो मेंशन किए हैं कि मेरा इस दिन का सेल डीड है
सेल डीड एनेक्स किए हैं
ये ऑर्डर में भी नहीं आया चेक भी नहीं किया सब इसे बिना चेक किए बोलना
and it is further not in dispute that respondent number 16, 17 and 18 have been impleaded at the first appellate stage, and that's all. ये मेरे रेफरेंस में आपको क्या बोलना है?
चूंकि अब ये बात उठना ही था तो रिप्लाई हमको देने पड़ेगा. Now first let us see what was the status quo order. That is order dated 23/3/2012.
Yes.
Well, steps shall be taken to serve the order respondents regarding IA number so and so. Submission of the learned counsel on behalf of the respondent 2, 6 and 7 is that no execution proceedings are initiated, but it's contended on behalf of the appellants that the respondents on the strength of impugned judgment order are trying to take forceful possession. Learned counsel has tried to demonstrate this assertion from documents. Taking all these facts and circumstances, I am of the view that since the appeal is admitted, respondent shall maintain status quo meanwhile. So this was with respect to forceful possession. Now the 340 proceedings, which I would like to file an application against the person, but who has filed this application and the person was trying to argue. Now what he has concealed. Now let us see that order. The order mentions about a contempt application. They had filed a contempt application. Now he chooses not to mention all these facts, that what happened in that contempt application. That contempt application has been dismissed. Now what is the order in that contempt application? This is the petition. But today since they gave us the petition today itself, so I was not aware. This is the petition by them and the order is at the back of it. So what action has to be taken against them for concealing this fact before this honorable court? That all these matter was thrashed in contempt. The court was constrained to write that counsel for the applicant are conversing arguments at length and after having heard for the other side seeking permission to withdraw the contempt. Finally the contempt application was withdrawn. All these issues, all these everything which is being canvassed now. Now he chooses to conceal one more fact, that they have already filed cancellation deed which is pending before the court and we all are fighting and they are not prosecuting that matter. They are trying to
counsel appearing on behalf of the respondent number 19 has submitted that the order of status quo has to be seen in the context it was filed. He has referred to the order dated 23/3/2012 and has submitted that the grievance raised in IA number 956 of 2012 was that the respondents on the strength of the impugned judgments were trying to take forceful possession of the property. He submits that it was in this context the order of status quo was passed. The learned counsel submits that there was nothing on board to even restrain any of the party to alienate the properties. The learned counsel has further submitted that with respect to the violation of the order of status quo, a contempt application was filed.
That is part of the order which they have concealed. They did not mention this fact to the court.
A contempt application was filed, which was contained case within bracket civil number 846 of 2012, although this contempt filing of the contempt application has been mentioned, but the final order passed in the contempt application was not brought to the notice of
They have not mentioned about the content. No, they have not mentioned.
कंटेम्प्ट के बारे में लिखा हुआ है कहीं तो कंटेम्प्ट के बारे में लिखा हुआ
ऑर्डर शीट पे लिखा है, लेकिन ये यहाँ पे आर्ग्यू नहीं किए, बता नहीं रहे।
बताया उनके बताने से मेरे नजर से थोड़ी चुप जाएगा क्या बोलते ये है तो have already moved against the plaintiff. It is already there.
That they did not mention.
Need not mention.
The application they filed here, they have also not mentioned. So
देखिए मेरा दिमाग कमजोर हो सकता है, नजर कमजोर नहीं।
That is why from the very first day I was sitting and just trying to say these issues are already being litigated in the court below. All these issues are
just a moment. The learned counsel submits that the contempt was ultimately dropped by the order
dismissed.
Disposed of as not pressed.
Disposed because
right.
After canvassing arguments at length.
After arguments, and it was sought to be withdrawn. And he has produced a copy of order dated 22nd February 2013, passed in contempt case civil number 846 of 2000. The learned counsel has further submitted that the sale deed executed in favor of respondent number 19 is subject matter of a suit.
Suit wherein they have gone for cancellation.
Suit filed by the respondent numbers 16, 17 and 18.
Filed by calls.
Filed by the plaintiffs.
Yes.
Filed by the plaintiffs seeking cancellation of those sale deeds. He submits that any pronouncement.
Plaintiffs / Pauls, not the power of attorney holder.
Whatever it is.
That also I'll see why this is
Plaintiff / power of attorney of plaintiffs.
No, power of attorney holder has not gone.
He will not. How will he go? Yes, he has executed the sale deed. Just ऐसे नहीं disturb करिए please. The suit is pending in connection with the cancellation of the registered sale deed. He submits that any pronouncement by this court on the legality and the validity of the sale deed will have a direct bearing in the suit. He submits that all the aspects of the matter can be agitated in the pending suit. Okay, आपको भी यही बोलना है? The learned counsel for the respondent plaintiff has also supported the arguments advanced on behalf of the respondent number 19.
My submission not in support, it may be independently reported.
Okay. The learned counsel appearing on behalf of the hold on. The learned counsel appearing on behalf of the respondent plaintiffs has submitted that the suit regarding cancellation of sale deed is pending before appropriate court, and therefore there is no scope for entering into the legality and validity of the sale deed by this court.
And Your Lordship, my ground, if Your Lordship is mentioning that, then my ground is that it was without authority and without any consideration.
The learned counsel has also submitted that on various grounds.
On
various grounds.
On various grounds.
These things.
नहीं बोलेंगे हमारे पास plaint नहीं है suit का
My submission.
दूसरा जो बार-बार ये कह रहे हैं कि so they have never mentioned.
ठीक है, हो गया आप लोग का argument.
16 to 18 they have never mentioned how much money did they pay for the land. 16 lakhs compared to our 3 crore.
ठीक है,
वो भी ठीक है, एक सेकंड. वो भी अच्छा
then I'll place on
you all argued. I did not say a word. I did not disturb
भाई
anyone.
आप लोग का right protect कर दिया
बस हम इतने I'm not filing also. But I'm not filing also by because
only one more thing. You may kindly see the order by which he was impleaded. Why I say, Your Lordship, the whole case was that he had filed claim to be impleaded as a party on the basis of registered deeds which were executed on the basis of the with regard to suit property. This was mentioned, and our claim was, while objecting to their impleadment, was that we had already filed a suit. That was mentioned in our submission, opposing their impleadment. Now, Your Lordship, the court, while impleading, it actually holds the conclusion portion is that is the that only maybe ultimately may not affect the ultimate outcome of the suit. That is all I know. Your Lordship may see, in view of the ratio laid down by Honorable Apex Court, the petitioner being transferring pendentally. That means he was being considered, this challenge ought to have been said that his sale was still under challenge, and that would be subject to the final outcome of that suit as well as this suit. So this is the only portion I must be.
This is order dated.
This is order dated by which he was impleaded. Page 24.
But I'll read that para 5. Is that is what your lordship is also saying? My rights are subservient to the Paul's. Yes, it is. If the Paul family
The
loses
council
that.
has also referred to, for the plaintiff, has referred to paragraph 5 of the order dated 14/12/2018 and has submitted that the intervention of respondent number 19 was allowed subject to the rider that the applicant will be entitled to pursue such defence as were available to the original owners, and such title shall remain subservient to the rights of the plaintiffs in the suit. He submits that the scope of the suit is confined. The scope of the suit cannot be enlarged to decide the interstate dispute, to decide the rights of the interveners.
Yes. Yes.
And your
Yes.
Lordship, it
That's
would only submission that it would also be subject to final outcome of that.
And the same
That is-
would, and the sale deeds will be subject to the final outcome of the pending suit. Yeah.
many of
Yes.
them. We had the list of dates we are not filling because now it
Not
is saying
required,
now.
हो गया इतना बहुत है. सेल डीड नहीं है उसका वैलिडिटी हम यहाँ बैठ के चैलेंज कर देंगे तब तो मुश्किल.
Perhaps there is no
अब तो और किसी को नहीं बहस करना है.
So on the last occasion, we had at the end seen the definition of state and tenure holder. So state is 2I
Yeah, land reforms
and
act.
tenure holder is 2A. State is the actual property which the proprietor is owning. Actual right over the physical right over the activity, and tenure holder is also right to take rent. For the, at the cost of repetition, if the lordship permits me to read out the definition of state and tenure once. Because the entire suit is with respect to tenure holders' right, not the state. State is section 2I, as the lordship got it.
Yes.
State means any land or several fishery or ferry rights included under one entry in any of the general registers of the revenue paying lands and revenue free lands prepared and maintained under the law for the time being enforced by the collector of the district, and includes revenue free land and several fishery ferry rights not entered in any register and a share in or of a state. It is a physical property. Now, Lordship, you can see what another word which is repeatedly being used in Lordship, intermediary. Intermediary is Lordship 2JJJ, Your Lordship. Intermediary in relation to a state or a tenure means a proprietor, tenure holder, or under tenure holder, or a trustee. So, Lordship, intermediary can be with respect to state also and tenure holder also. And intermediary includes the proprietor. Proprietor word will be Lordship corresponding to the state. My submission is Lordship. And tenure holder, under tenure holder, or trustee. Now, Lordship, can you permit me to place the definition of proprietor?
Intermediary interest is in relation to estate or
State
tenure,
and
both.
tenure both.
So intermediary is relatable to both.
Both. Now, Your Lordship, proprietor, I said, Your Lordship, proprietor is relatable to the state only. Wherever the word proprietor has been used. That would be apparent if Your Lordship says 2O, proprietor has been defined. Proprietor means a person holding trust or owning for his own benefit and state are a part of a state and includes the heirs or successor in interest of a proprietor, or a proprietor is a minor or unsound mind, such as a guardian or legal. So proprietor word will be used always with respect to a state. There cannot be any proprietor with respect to tenure holder. Now your lordship, can you come to lordships 2L, tenure holder.
Who are?
Yeah, I beg your pardon. 2R. Tenure holder means a person who has acquired from the proprietor or from other tenure holder a right to hold for the purpose of collecting rent, bringing it under cultivation by establishing tenant on it and includes. Lordship, before reading below, Lordship kindly mark 3 words. A right to hold the land for the purpose of collecting rent, one, of bringing it under cultivation by establishing tenant, not bringing it under cultivation for doing cultivation for himself. On it and includes a successor in interest of a person who has acquired such right, a person who holds such a right in trust, the holder of a tenure creates for the maintenance of any person, or a ghatwal, or the successor in interest of a ghatwal, where the tenure holder is a minor, unsound mind, or idiot, his guardian or committee, or legal curator. So, Lordship, tenure holder cannot hold any property for himself. Am I clear? Now, if your Lordship, in this background, if your Lordship sees the suit, let Lordship, there are specific cases.
So you want to say that the tenure holder cannot have any right on his own. His entire right is only collection of rent.
Collection and appropriation of rent. So he will be compensated on vesting. So that is what I submitted. Lordship said that
So
he can
therefore,
have his own.
there is no question of having your independent title in connection
Yes.
with any land.
What has been mortgaged to them as per their own pleading is tenure holder's right. So the tenure holder's right was a recognized right prior to vesting. After vesting, there is no tenure holder because it is the state who is taking. So what point I want to make is I had a right of a tenure holder with respect to 2 annas of share. That doesn't mean I did not have any state or any property on my own. That is not their pleading. What was mortgaged as per their own pleading is the tenure holder's right. And what they got it auctioned is also what I have been mortgaged, that only can be auctioned. What they purchased is also the tenure holder's right at best. And tenure holder's right, Lordship, got vested with the state government. And Lordships, after vesting, they were compensated for the right which has been taken over by the state. Because after vesting, the state will be collecting the rent. So they lost the collection or the cultivation done through tenant, that income. So they have been compensated for that. So they cannot have any proprietary right in lieu of this mortgage or in lieu of this auction sale.
So far as this mortgage property is concerned, they do not have any.
So mortgage is with respect to Lordship, their specific pleading is mortgage is with respect to our tenure holder right. Lordship will kindly see Lordship for the Lordship satisfaction the plaintiff.
No, that's right. We are aware of this.
Yes, Lordship. Permanent tenure holder's right was mortgaged and that was the Lordship's invoked or forfeited your Lordship and that was purchased by auction. And as your Lordship, we had been arguing that all these sale certificates do not contain any description of property because perhaps that was not possible. Because out of 16 anna share, they claim at their highest cases they purchased 6 anna share. 6 anna share to collect rent over a property, but you cannot be described by giving boundaries. Therefore, the sale certificate says 2 anna share, each sale certificate says 2 anna share of tenure holders right.
So it is undivided right.
Lordship, division is Lordship, the right to collect 2 anna shares is Lordship 2 out of 16, but 2 out of 16 or 1/8 share of the entire rent which was to be collected from the.
So if 100 rupees is to be collected, if 16 rupees is to be collected,
They
they
will
are
get
entitled to
2 rupees. So in that manner, if they say their case is to be accepted, all 16 annas, 6 annas they have purchased. So out of 16, they will get 6 rupees. But 6 rupees from no specific property because that is the share of income from the tenure holder which was mortgaged.
So this 6 annas was sold.
This 6 annas was sold and this
So
100 by
you have lost right over this
this
6
share,
annas.
yes. Otherwise also
You had share of only 6 annas.
Lordship, we had share of tenure holders. Lordship, therefore I said BLR Act recognizes two type of properties. One state which comprises of Lordship homestead land or agricultural land which I own, which I use, or a fishery or a mine which I own. It is not their case that we did not have any other property. Lordship, tenure holders right. Whether Lordship I would have mortgaged or not mortgaged, I could not have retained after vesting. Lordship, that was vested, they got the compensation. Lordship, a question fell from Lordship that compensation includes also the land compensation of acquisition of private land. Lordship, private land with respect to state, there is no pleading.
There is no private land when it comes to tenure.
Tenure holder. And there is no pleading that we had mortgaged any part of our state. The state word is missing in the entire plaint. And if your Lordship sees thereafter section 19, though I have read the Lordship, if your Lordship permits me to read once again.
Just a moment. The learned counsel for the respondent numbers 10 to 15. 10 to 15
10 to 15.
has referred to the definition of has referred to section 2 within bracket I, 2 within bracket JJJ, 2 within bracket O, and 2 within bracket R. To submit that the concept of estate is different from concept of tenure holder. So far as the tenure holder is concerned, it is relatable to the right to collecting rent or to bringing land under cultivation by establishing tenants. He submits that the specific case of the plaintiff was that Pauls had right as tenure holder and there's 6 annas.
No, Dattas had right as a tenure holder.
Dattas had right as tenure holder and their 6 anna share was sold in mortgage suit. He submits that once the right as tenure holder was sold, there was no further property left to be sold as a
No
right of
further-
tenure holder.
As a right.
As a right of tenure holder. He submits that the properties involved in this case are the properties other than the properties which was covered by tenure holder.
And it is their own admission in the plaint para 3 if your Lordship sees. They themselves admit that Sasiwala died issueless and her 2 anna share in Moja along with other lands were inherited by them. So they admit besides 2 anna she had other land also which was never mortgaged as per their own admission.
The learned counsel has submitted that in paragraph 3 of the plaint, it is the case of the plaintiffs that Shashi Bala expired and Shashi Bala had mortgaged her 2 anna share.
No, Sasiwala died issueless.
Shashi Bala died issueless and
Her 2 anna share along with other properties were inherited by Chandra Mohan Datta.
and her 2 anna share along with other properties were inherited by Chandra Mohan
Datta.
Datta.
And thereafter, Lordships, it is said
Which
that
goes to show that there were other properties over and above the properties covered by tenure holder.
Yes, Lordship. And this fact will be further proved, Your Lordship, that we had other shares also. Lordship, they had shown, Your Lordship, that they got the compensation against wasting of land, Your Lordship, under BLR. They have also brought on record that they have got compensation against acquisition of the land. Lordship, we have also filed the document saying that when our part of the land was acquired, we also got compensation. Lordship, that is exhibit G, if Your Lordship sees. And we have brought on record the checks also through which the compensation was paid to us. Which goes
Exhibit
to
G.
show,
Compensation was paid to them also.
yes, Lordship, against acquisition of land.
Exhibit G दिखाइए.
That, not a new document, Lordship.
Exhibit G.
G, yes.
The learned counsel has also submitted that the fact that other land was available is also apparent as compensation arising out of land acquisition was paid to the plaintiffs and compensation in land acquisition proceedings was also paid to the defendants. And for that purpose, he has referred to Exhibit G, which is arising out of land acquisition case number.
Lordship, it is arising out of land acquisition case number 3 of the 2004-05.
Land acquisition case number 3 of 2004-05
With respect to Mauja Ranguni only.
with respect to the same Moza, that is Moza Ranguni. That order sheet is there.
Lordship, the pro forma, your Lordships, is there, followed by the checks which were exhibited.
He submits that the pro forma regarding acquisition of land along with the checks
The
have
pro
been
forma regarding disbursement of compensation along with the check.
property details नहीं है उसमें.
नहीं खाली मौजा लिखा हुआ है Lordship. मौजा और एरिया लिखा हुआ है और डिस्चार्ज क्या था
कितना
मकान.
एरिया है?
सर्वे क्षेत्र नंबर 871 लिखा हुआ, खाता नंबर 46, मकान. And the compensation
He
determined
submits
was
that the compensation relates to khata number 46 and the building standing thereon.
yes Lordship.
Area?
Lordship, exact area नहीं लिखा हुआ है. Compensation amount लिखा हुआ है 34,551.06.
And compensation amount is to the extent of rupees 34,000 and all.
Yes Lordship. And
The
check which
corresponding
was-
checks
Yes.
have also been exhibited along with Exhibit G.
Yes, Lordship. Those are marked as exhibit G/2, G/3,
Which are marked as Exhibit
G
by-
series, your Lordship.
as Exhibit G series. This is with respect to khata number 46.
With objection.
Exhibit G with objection. ठीक.
Lastly, Lordship, so far as the this one I had also argued, but they are not clarified. I'm just highlighting it once again. The 3 M forms which they have filed, Lordship, that does not contain any keyword number. Lordship, in absence of keyword number, they cannot correlate. Lordship,
This
we
is
tried-
just a khata number 46 or keyword number 46?
Lordship, इसमें खाता number 46 लिखा हुआ है. Survey plot number, no, it's not. It is survey plot number 46. No, खाता ना आएगा खाता number 46. And survey plot number 871 with respect to one.
Survey plot number 871.
871, and therefore also the other compensation is with respect to khata number 67, survey plot number 375,
Khata number 67, survey plot number
375,
375.
and other was also 871. 2 of 871 and 1.
This is LA case number 3 of 2004-05.
Yes.
Both the
All
compensation.
the three compensations.
3 compensation कैसे हुआ? आप तो 2 ही बताएं.
नहीं, दो एक ही खाता का है, अलग अलग हम बता दें.
खाता number 46.
जो खाता नंबर 46 में
हाँ.
Lordship, फर्स्ट है 871 प्लॉट नंबर.
871 plot
Yes.
number. दूसरा
उसमें 34,551.
ठीक है, amount is not
जी.
relevant.
दूसरा खाता नंबर 46 प्लॉट
46
नंबर 871.
871.
हाँ, उसमें अमाउंट है 36,000 and all.
अच्छा.
अब तीसरा है लॉर्डशिप खाता नंबर 67 प्लॉट नंबर 375. इसमें अमाउंट है 24,288.
इसको ऐसे लिखेंगे पंकज. In NA case number 3 of 2004-5, there has been 3 disbursements
Yes,
in favor of the defendant number 5 to 10. One is in relation to portion of khata number 46, plot number 871. Other is khata number 46, again part of plot number 871. And third is khata number 67, portion of plot number 370. अब last submission क्या बोल रहे हैं?
जो लास्ट सबमिशन है, ये लास्ट एक और सबमिशन जो फॉर्म एम है, जो प्रीवियसली हम लोग के पास जो कॉपीज था उसमें लग रहा था कि कुछ स्क्रिबल्ड होगा, बट वी गॉट दिस सॉफ्ट कॉपी, वी एनलार्ज्ड एंड सी लॉर्डशिप देयर इज नो मेंशन ऑफ एनी केवर्ट नंबर
In all the forms.
in all the 3 M forms were lordship. Total suit is with respect to 5 M forms.
That we are
Yes.
3 M forms, no keyword number.
No keyword number is there.
There is no description of property.
Lordship, plot numbers are there, khata number and plot numbers are there, lordship. That are also with not matching with the lordship the M form numbers and description which has been given in the suit. If your lordship sees the plaint, they have very categorically stated that this M form X corresponds to this khata this. Nothing is matching. And last lordship, last submission will close it. Lordship, the suit has been filed through one power of attorney holder, Tarun Kanti Ghoshal. Lordship, may kindly see the list of exhibits. This power of attorney has not been exhibited. Rather, Lordship, Exhibit 4 is a legal notice sent by Tarun Kanti Ghoshal on behalf of the cause, which shows that he is an advocate. Lordship, he has nowhere stated that it has been filed through a power of attorney holder. Lordship, the power of attorney is required to be exhibited. What kind of power has been given, Lordship? That document is not on record. And perhaps, Lordship, in the appeal.
The suit has been filed by power of attorney.
Yes, kindly see the cause title of the suit. Yes.
Yes, they'll at least point out in their written statement, this defense case has to be taken. If there was any technical
They have to
issue.
stand on their own legs, Lordship. If the suit has
So,
been filed.
can I be asked to submit things which are not disputed by them before the trial?
The cause title shows all such and such represented through a constituted power of attorney. Lordship, that power of attorney they have never exhibited. Lordship, rather, Lordship, their own document shows that in fact he was a lawyer who was engaged in Lordship for sending a legal notice.
The learned counsel submits that none of the 3 forms which were exhibited in connection with which were exhibited by the plaintiffs gave the details of any keyword number. Rather, only khata number and plot number was mentioned, which is not matching with the suit property. He has further submitted that the suit was filed by Tarun Kanti Ghoshal, who claimed to be the power of attorney holder of the plaintiffs, but the power of attorney was never exhibited before the learned court. और ये तो डिपोज में नहीं किया होंगे.
नहीं, ये डिपोज में नहीं किया है.
And nor the power of attorney has deposed before.
One more thing, Lordship, to add. Lordship, the son of the original plaintiff number 1 has been examined as PW1. Even he has not whispered anything about the power of attorney.
The learned counsel has also submitted that none of the witnesses on behalf of the plaintiffs have whispered anything about the power of attorney.
So one judgment only on the issue, Your Lordships, that initial onus, that I need not cite, but still, Your Lordship, that initial onus to prove the case is on the plaintiff, and only, Lordship, after he leads the evidence so that the high degree of probability has been proved, the suit has been proved to the highest degree of probability, then only the onus will shift upon the defendant, not before that.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported.
Also 2000, just 2022 is live
Bracket,
laws.
2022 live law within bracket SC 19
More particularly para 31.
and has in particular referred to paragraph 31 to submit that the burden to prove to establish a title is upon the plaintiff who asserts the existence of a particular state of things. And such mandate is in terms of section 101 of the Evidence Act, which states that the burden to prove the fact rests with the party who substantially asserts in the affirmative, not on the party who is denying it.
And also will appreciate one more fact. As a cause title is not the part of the verification or part of the affidavit in a plaint. Also there is no corresponding statement that it is being filed by this. So there was no, also will give a reply to the contentions made in the plaint only. This they have to show that yes, I had a valid power of attorney to maintain the suit.
Suppose a power of attorney is filing a suit, and if the person who has got the plaint filed through a power of attorney is himself coming and deposing before the court.
Yes, he is proving that I have given the power. He has not actually
No, even if he does not prove that I have given the power,
yes.
but he is coming and deposing before the
Son
court.
of one of the plaintiffs.
That's right, son of one of the.
Also, there are
plaintiffs.
several plaintiffs together. Also, they have to show that we have given the power to some person, and that power of attorney has to be taken on record. Also, there is separate. If there is no procedure, it has to be exhibited. Like in our High Court, there is a procedure that we have to just file it with the register. Also, the registrar generally has been made the registrar to keep the to maintain a registrar of the power of attorney. A separate register is maintained. Once we file it, it will be with him till the disposal of the case, and we get a certified copy of it.
Was there any cross-examination on the point of power?
No, there was no statement. There was cross-examination will be on the basis of meeting the lordship. But we asked him various questions. I had read out the lordship. He was not even aware about the nature of the property, which are the properties. He could not say anything. That I had already pointed out. Lordship was already taken.
That's all. Before I ask the appellants to respond, a few new facts have come which they had not urged at the time of initially they had not argued. If you have to say something on that, like this power of attorney, and then the point of exhibiting certain documents which you had raised. If you have to supplement your argument, you can supplement it, and then I'll call upon the appellants to respond.
It is only after me they will be argued. Then I'll
You have to.
yes.
Because ultimately consolidated reply will have to
Take.
come from there.
I'll
Synchronize that,
Then-
synchronize my argument.
then tomorrow.
Why tomorrow?
It's already 4. I can start.
No, you
It
can
would be
go
better
tomorrow.
that your lordship I'll start.
Chance to prepare.
But prior to he starts, I'm surprised. The issues which were raised by the council, that there's a detailed order on this point in the previous order with respect to contempt. It's a 2-page order. The same execution of the sale deeds, and those sale deeds were executed while there was a status quo order. And everything in detail the court dealt and dismissed it. The previous contempt, it was just 1-line order, but the order in contempt case civil number 700 of 2012, everything has been dealt in detail. That's what I'm saying. Because we were caught by surprise that these things would be raised. We were not aware. So should I just place that contempt 700 that is part of the previous order?
700.
Yes. Contempt case civil number 700 of 2012.
700 consequences. There is no 700 contempt.
The previous order, the judgment
The
passed by
judgment which has been set aside.
that only 43 has been set aside, not the contempt. That
देखिए
contempt.
आपको सुन लिया
एक चीज-
क्या
एक चीज-
क्या करना है
क्यों
आपका
क्यों बोल रहे हैं ना, क्योंकि वो इतना कितना गलत सारा चीज इसमें डिटेल्ड में लिखा हुआ है। हम जरा एक बार पढ़ 1
ये
मिनट
कौन कंटेम्प्ट फाइल किया था किस
यही-
केस से अराइज कर रहा है
सब-
इट इज अराइजिंग आउट ऑफ व्हिच केस
same status quo.
व्हिच केस
This first appeal, and this part of the judgment of the first appeal which has been set aside by the Honorable Apex Court, but this contempt case civil has not been set aside. All these issues with respect to nine registry of 9 deeds, then the registrar against the registrar, all these facts were raised before the court, and the court by way of detailed order dismissed the contempt and said no, all these things nothing to do.
And this judgment has been upheld by the Supreme Court.
Yes, only 43 has been remanded back, the contempt has not been remanded back. These they have concealed again this also. आप ये वाला देख लीजिए खाली कुछ
Remand order में है.
हाँ यहाँ के जो जजमेंट पास हुआ था उसमें कंटेम्प्ट केस सिविल नंबर 7 एट 11
एक चीज लिखेंगे तो इसमें the learned counsel for the respondent number 19 has also submitted that along with the present first appeal being first appeal number 43 of 2012, contempt case civil number 700 of 2012 was also decided, and what has been remanded before this court is only the first appeal number 43 of 2012,
but
and the order passed in the contempt case has
remain
remained intact. Video को वापस करो.
On the last occasion, Mr. has already recorded my submission to the extent that none of the document which they have produced they can correspond it with the suit property. That I argued initially also last.
आपका हर एक ऑर्डर अपलोड होता है, आपका काम है वेरीफाई करना आपका सबमिशन राइटली रिकॉर्ड हुआ है. रोज आपको क्यों बोल रहे हैं कि आप अपना ऑर्डर देखिए.
नहीं,
कोई भी केस में अगर कुछ चीज छूट गया है, अगर आपको नहीं याद है कि आपके ऑर्डर में क्या रिकॉर्डेड है, हमको याद रहेगा. आपका काम है ऑर्डर देखिए और समझिए क्या ऑर्डर में लिखे हैं, क्योंकि दैट इज माय मेमोरी. बस वही मेरा मेमोरी है जो ऑर्डर में हमको दिख रहा है.
yes, that has been recorded.
Must have been. छोड़े तो हमको भी नहीं.
Prompted me, I recollected that it was already argued. And misgender and non-gender also had also argued in election that.
आपका तो सब जो हो गया सब रिकॉर्डेड है आपका, उसमें सारा कुछ रिकॉर्डेड. ये पावर ऑफ अटॉर्नी के बारे में आपको क्या बोलना है?
With regard to power of attorney, this was firstly not raised in the written statement. So any technical objection with regard to the right to file a suit, that was essentially required to have been pleaded in the original pleading itself. That by raising this, what is the ultimate outcome? That they want to say that the plaintiff or the power of attorney holder did not have a right to sue. This is all. So this ought to have been raised before in the original pleading itself, which if they have not done, then they cannot raise it as a ground when the suit has been decreed and appeal is pending.
The learned counsel for the plaintiff has submitted that the objection in connection with power of attorney was never raised at the stage of suit, and therefore the suit as filed was maintainable. He has also submitted that since there was no objection with regard to the status of the power of attorney, the non-exhibiting of power of attorney by itself is not fatal to the suit.
Particularly when the plaintiffs have not challenged. It is for the plaintiffs who have said that I have not given any power. It is the defendant cannot raise this issue. If the plaintiff
Yes.
has ultimately come in witness box and he has
He has further submitted that the plaintiffs had ultimately led evidence before the court,
absolutely.
both oral and documentary, and therefore there was no doubt that the plaintiffs had authorized the power of attorney to file the suit.
Yes. Now your
And
lordship,
ultimately the suit was contested by the plaintiffs themselves.
now with regard to agency, if your lordship would kindly see contract, this deals with section 200, 196 onwards. This specifically deals with how the agent would be appointed and what would be the right and liabilities of the party. So if your lordship would turn to, so in this case, let us assume that he did not have power or all. So ultimately when the person who subsequently acknowledges that yes, ratifies, I was the principal, I ratified the action of my
I think that is
agency.
sufficient.
So
इससे ज़्यादा
therefore, no, because all these technical objections, they were required to have been raised in the written statement itself. Now, Your Lordship, much has been argued with regard to the identity of properties and what was sold, what was mortgaged. This is important. What was mortgaged and only the mortgaged property was sold. So this is the main crux of their argument, and their
that
argument
is at the core.
and it was not a property, it did not contain immovable property. This is their whole contention, that it was a tenure holder's right, that right was
Collection
not,
of rent. That right was collection of rent,
yes,
and that was mortgaged.
that was mortgage, this is their contention. Now my contention, let us assume that it was only tenure holder's right to collect rent, that was mortgage. But ultimately, the effect is that the moment the mortgage decree was passed and it was decree in execution, all the immovable properties were executed and delivery of possession related to immovable property. Absolutely specific properties, they were executed. So what the mortgage suit, once it was decreed, then if it was not realized in the mortgage proceeding, execution proceeding, then personal decree against all those persons, it was the personal properties of those persons. Therefore, Your Lordship would recollect that Shashi Bala, there was no decree against Shashi Bala. But we say, we have stated in our plaint that even the properties which belong to Shashi Bala, it was inherited by Chandra Mohan, and ultimately those properties were also auction sold and delivery of possession took place. So this is our contention. Now, 841, that title suit which we have referred, Your Lordship may kindly see what was in question there, and that was the closest in point of time to decide as to what was there in existing in 1941. Now in 1941, before 1941, this auction sale and 2 annas interest and all those were already in question, and during the pendency of this execution case when it was going on, then what happened? Then Chandra Mohan Datta, he executes a deed of gift with regard to immovable properties. This is very important. Not with regard to tenure holders' right. He executes a deed of gift conveying, gifting certain immovable properties to his own daughter-in-law. So when in the execution case, those properties they objected and those properties were taken out from the execution case, we filed title suit that was numbered as 8 of 1941, and in that title suit, that Your Lordship may kindly take the paragraphs. This for the first time because all these
At the time of your arguments, you did not refer to the statute.
I had referred, but detailed reference was not there. Now this would actually clarify many things. Therefore, Your Lordship may see
This exhibit.
exhibit is.
आप लोग अपना नोट्स बना रहे हैं ना? कब मिलेगा हमको?
जब उसका 2 या 3 दिन लेंगे।
ये कौन सा सूट की बात कर रहे हैं? I'm not able to
That
comprehend
is
this.
exhibit 2/A.
This has not been referred to.
It
It
was
was not referred. And if the Lordship sees the properties described there, also let me learn it. I'll give the paragraph number when the properties are in. It does not correspond in this.
Now I am replying. Kindly allow me.
दीजिए exhibit 2 by
Exhibit.
It is 1 by B, 1 by C. 1 by B and 1 by C. Specific 1 by C.
One by B and 1 by C.
These are two gift deeds.
No, these related to the transfer. Then the suit was filed by us, and this is the decree as well as the judgment passed by the trial court in title suit number 8 of 1941.
8.
Of 1941.
This is challenging the gift deeds.
Yes. Gift deed executed by Chandra Mohan Datta in favor of his own daughter-in-law. So, this your lordship had read, but
1 by A. This is mortgage suit. 1 by A.
1 by B your lordship may take.
1 by B, yes, 8 of 19.
1 by B is the decree
Yes.
and 1 by C is the judgment.
Yes, we have read it.
Yes. So I'll only refer to specific paragraphs. I'll be placing your lordship may allow me to place first page and then I'll be skipping to other. Subsequently, we have got fresh certified copy of that. So if your lordship's copy is not legible, then only I'll give it.
It is okay.
Your lordship may allow me to read first 2 pages. What was the issue in that title suit, and then I'll refer directly to the finding. This title suit is under Order 21/63, arises out of an order dated 15/1/1941, passed in a claim case number 54 of 1940, filed in execution case number 1438 of 1940 of this court. Defendant number 3, Surendra Datta, is one of the sons. Defendant number 4, Nandgopal Datta, is a grandson, and Jhatila Dasya, defendant number 5, is widow of a predeceased son of Chandra Mohan Datta. Defendant number 1 and 2 are both daughters-in-law of Chandra Mohan Datta. Defendant number 1 being widow of Jhatila Datta and mother of defendant number 4, and defendant number 2 being the wife of defendant number 3. The facts are these. The plaintiff instituted a mortgage suit number 61 of 1928 against Chandra Mohan Datta, wherein final decree was passed on 23/11/1929, that a decree was put in execution case number 492 of so and so against Chandra Mohan Datta, and certain properties were auctioned, sold therein and purchased by the plaintiff. Later on, the plaintiffs obtained a personal decree dated 23/4/1938 against Chandra Mohan. That decree was put under execution in execution case number 144 of 1938 against Surendra, defendant number 3. Only one of the sons of Chandra Mohan, and certain properties were auction sold and purchased by the plaintiffs. Afterwards, the personal decree was again put under execution in execution case number 138 of 1940 against Surendra Datta, Nanda Gopal Datta, and Jhatila Dasya. During execution proceedings, defendant number 1 and 2 filed a claim case aforesaid, claiming certain properties on the basis of registered deed of gift dated 9/6/1934, executed by Chandra Mohan Datta in their favor, and the claim was allowed. Then your lordship may skip to the next page, page 3. And your lordship, only one thing I must point out, there are several page numbers in that particular document. Your lordship may only take one top right corner page number, that is in second page your lordship would find. Page number 2 it has been mentioned. That is the page number which is actually page number. There are several other page numbers. Then page 3, para 2. The plaintiff further alleged that Chandra Mohan who was heavily involved in debts with a view to defraud his executors and with a malified object of saving his properties from their clutches, executed deed of gift as aforesaid on 9/6/1934 in the names of his 2 daughter-in-law in respect of the properties detailed in Schedule Kh of the plaint and other properties. So what was under challenge was Schedule Kh of the plaint. And Schedule Kh of the plaint, if your lordship would kindly turn to, in the ultimate decree, that portion has been mentioned, what is in Schedule Kh.
It's here in the decree it is mentioned.
उसमें ये लो चिप
3 आना शेयर
हाँ वो ठीक है उसके लिए नहीं आई जस्ट वांट टू आंसर देयर स्टेटमेंट दैट इट वाज समथिंग व्हिच वाज नॉट it was vague or only tenure holders right was sold and not the option sales were not of immovable property. This is the whole contention which they are making. So with regard to
they
answering
say that this is a specific case of the plaintiff, that it was a tenure holder property which was mortgaged, and tenure holder property is necessarily means the right to collect rent, and therefore the mortgage was not that of tenure holder,
no
of the immovable property.
yes. So I have to only show that immovable properties were ultimately auction sold and delivery of possession took place. This is the only thing I can show. If I can show that ultimate delivery of possession was related to immovable property.
For realization of the dues under the mortgage.
Yes.
There could be a situation that the mortgage is of tenure holder rights,
Yes.
but the auction sale is relatable to immovable.
Exactly, this is my submission. Exactly. So let us assume that because Your Lordship, the whole pleading, ultimately whole pleading has to be seen. The pleading is that let us assume that it was only a tenure holder's right, which did not contain a immovable property, but ultimate execution was related to the immovable properties, and all those immovable properties were auction sold. And therefore, what happened that when in execution all those amount was not realized, then immovable properties were sold, and when Chandra Mohan executed two gift deed to his own daughter-in-law, that was annulled by this order, by this
By
judgment
saying
and
that
decree.
it was already sold.
Yes, exactly. So the ultimate effect is that the deed of gift was annulled on the ground that this was executed in order to defraud the creditors. This was the finding of the trial.
The learned counsel appearing on behalf of the respondent plaintiffs has referred to exhibit 1/C, 1/B and 1/C, which is the decree and the judgment passed in title suit number 8 of 1941 respectively, and he submits that in the said suit the gift deed executed by Chandramohan Datta were under challenge, and the gift deeds were set aside on the ground that the property was already auction sold.
Yes.
In the execution case arising out of mortgage suit number 61 of 1928, was ultimately sold out in the execution case
Page 36 is the conclusion of the trial.
कौन सा केस नंबर नहीं है
Page वही ऊपर में जो corner में I said 36. Because Your Lordship, other typed pages are absolutely missing in the document. Page 36, just before issue number 6. On a consideration of the evidence as a whole and the facts and circumstances, I accept the evidence of PW1 to the effect that the deed of gift was benami and collusive document and was brought into existence to defraud the plaintiff. I hold accordingly.
Page number 36.
Page
36.
36 at the top, Your Lordship, corner, just before issue number 6.
Yes.
इंटरनल वो पेज 18
Yes,
कहीं
yes.
पर लिखा हुआ है लेकिन
Yes. यहाँ पे पेज 48 लिखा हुआ
वही ना वो Your Lordship, same document, it seemed that it was typed by several typists
And again they have renumbered as 18, but ultimately this is the entire copy which I have.
The learned counsel has submitted that it was held that the properties in suit. This is not the thing. In view of my finding on issue number 3.
Your Lordship has page 36.
I have got internal page 11 and then at the corner page 48. Then there is page 18 also mentioned somewhere. 18 and 36 is mentioned on the same page. The learned counsel has submitted that it was held that on the consideration of the evidence as a whole and facts and circumstances, the court accepted the evidence of PW1 to the effect that the deed of gift was benami and collusive document and that was brought into existence to defraud the plaintiffs. Okay?
Then Your Lordship, other two issues were decided for determination of issue number 6. For determination of the question of plaintiff's title to the disputed lands. So again land is in question. To the disputed
The
land.
learned counsel has submitted that even if the tenure holder's right was mortgaged, but in the mortgage suit, the property which was auction sold was the immovable property.
Yes, in execution.
In the execution
Exactly.
case. And therefore nothing survived with the third party.
Yes. And issue number 6, Your Lordship may see the questions, those were formulated, that whether, Your Lordship may allow me to read, following points arise for determination whether 2 anna's share of Chandra Mohan, which he held in Mukarari right, related to the share to that extent in entire village Ranguni, or that was exclusive of properties included within Kevat number so and so. So here what he says, that it includes these immovable properties which are there in Kevat, or it is exclusive of these properties. So ultimate finding of the trial court was that it was not in all these properties were included.
I want to see the final portion of the judgment and the Lordship permits him to match it with this property. Only one anna share.
Paragraph 42, page 42.
Page 40.
Yes.
The learned counsel has submitted that the court had come to the conclusion that 6 anna share of the entire village Ranguni, inclusive of all lands of the village, appertaining to the share, was given in Mukrari to Srihari Datta under Patta. It was marked as Exhibit D by 2.
And who was Sri Hari Datta? He was Chandra Mohan's father.
He submits that Srihari Datta was father of Chandramohan Datta.
Lordship would be allowed to. This page 7, if your Lordship would see who are the heirs of this.
That's right. I
This is-
I don't think that disputing.
That is, so all other clarification is already there in this particular page. So in page 7 it is there. Then after your Lordship was reading page 42. After this line it says, in that view I am of the further opinion that
You just see internal page 4.
internal page 4. From top itself, may I read or?
No, you just see that. I may state that Kevat number 34567 were recorded separately at Mukarari Kevat. Some of them in the years of Jagdhatri and others in the name of some transferees. On the reference to the record of right, it appears that Mukarari Kevats, that other Mukarari Kevats were also prepared in respect of village Ranguni. Out of them, number 10, 11, 12 and 13 represented 2 Ana share of the entire village. And number 25, 26, 27, 44, 46 and 48 represented remaining 2 Ana share of the village. So area wise and Kevat wise also it was mentioned over here.
Yes, it is mentioned. So their whole contention is, this is falsified from this particular document itself. Their whole contention, there are 2 arguments is there. So their contention that only tenure holders' right was auction sold is falsified from the fact that the immovable properties litigation went, and in litigation ultimately it was decided that the properties which were transferred by Chandra Mohan in favor of his own daughter-in-law, those were void and illegal documents. So that particular judgment of 841, it meets that question. So therefore my submission would be that now, and this is not in their pleading. It is not in their pleading, because my pleading is that it was mortgaged and then auction sold, entire property. Now they have not pleaded that no, only the tenure holders' right to collect rent was only mortgaged, and therefore what was auction sold was only a tenure holders' right to collect rent and nothing else. This is not their pleading.
But they have tried to show from the statute itself that tenure holders' right means only collection of rent.
Yes, let us assume that also. Let us assume. So that was only tenure holders' right was not. But ultimately what happens that it has come from this judgment also that it was executed on the personal properties of those judgment debtors, and they were put to execution, and immovable properties were auctioned. This is my point.
The most important task for you would be to match the
Let us, your Lordship, civil
This is something
cases.
which is very
Absolutely. For two
unless
reasons.
your properties are matched 1 to 1. Very
I'll say only one thing. My Lordship, the Honorable Court has to decide on the basis of preponderance of probabilities what is there. Now my case vis-a-vis their case, your Lordship may kindly see. My case is very plain and simple that the tenure holders' right, let us assume, were mortgaged, and all the immovable properties of the Dattas, those were auction sold, and entire properties were auction sold, and then we were put in possession, and then ultimately when the vesting PLR Act came, their interest vested, then we were treated as ex-intermediaries, and on that basis the compensation for vesting of our tenure holders' right was given to us despite their objection. So we stepped into their shoes, and with regard to the properties which were held by them, let us assume by them, then because we had stepped into their shoes, so with regard to those properties, rent assessment cases took place, and then rent was also assessed. It is not a case that rent was not assessed. So in those two proceedings, they have attained finality. Final orders were passed in both the proceedings, and no suit whatsoever was brought after that. If they were aggrieved, they were required to, although it is barred or not under section 34 of BLR Act, that is a separate question. But no suit was brought by. That no, it did not contain the immovable properties, and only tenure holders' right was transferred, and therefore the M forms which are there, which have been rent has been assessed in the names of Pauls, those are bad because we still retain the right to those properties. So once these final orders were passed, then that was required to have been challenged under section 8. So they impliedly admit all these things they admit that rent assessment cases took place, but those were illegal. This is the only contention. And they have also admitted in their pleading that the rent assessment cases were and M forms were issued with regard to the scheduled property, Schedule A property. This is very clear admission on that. So once that has been done, then next step is then when they transfer certain properties, then the persons to whom they had sold the property, they claim compensation. I am being paid compensation. Ultimately, when subsequently in 1981-82, they get their M forms rent assessed from the circle officer, that order was set aside. So as on date, everything matches. Now, if their case is compared, your Lordship may see what is their case. They say that they were ex-intermediaries, they had certain properties which were left with them, and then after vesting they became rayats. Absolutely, the rent assessment cases which took place, they were set aside. So ultimate effect of the revenue orders, revenue court's order is that I am still the rayat, and those orders have attained finality.
How many sale certificates are there?
Altogether.
You see the finding at internal page 43, or
Of?
maybe 6 of that judgment.
Yes. So here it was a
He is
case.
recording as to what is the property covered under each.
So this was a case where entire execution, it was only related to one execution. It was 138 of 1940, and then while deciding the properties which were transferred by Chandramohan in favor of his own daughter-in-law, that is the only property which was in question in that proceeding. Other execution cases were not in question in that proceeding.
There is full discussion on that.
It has been described which
Execution
property
case
was
number
option
492 of 1935.
Yes, yes.
Then execution case number 144 of 1938.
Till that
And
date,
execution case number 138 of 1940. These are all discussed over here. Then execution case number 138, yes, it is here. Have you seen that?
I have seen, Your Lordship, but apart from these, there were other, to Surendra Mohan Datta's properties were also there.
How is Suren Mohan Datta related to Chandra Mohan?
His brother's son.
Nephew. We are concerned with three three
Yes.
execution cases.
Yes.
One is 138 of 40.
Yes.
The other is 138 of 1940. Other is 492 of 1935. Exhibit 7 was there. And third one is 144 of 1938.
Lordship will only see the last page of the judgment. It has been summarized what was there with them and what was directed to be sold. Your Lordship.
Ordered.
Just ordered. That the suit is decreed modifiedly. It is hereby adjudicated that plaintiffs have got title to properties bearing khewat number 22 by 1, 22, these are sub properties we have looked, 22, 20 by 2 by 10, 22 by 1, 28, 51, 52, plot number 502 and 503, as also to the share to the extent of 1 anna out of 6, if it is 1 anna out of 6, not 1 6, of plot number 299 and 300, and to the extent of 2 anna out of 6 of plot number 422 and 423 of village Ranguni, and the plaintiffs are in possession of all those properties from before of the filing. These are with respect to next paragraph is also important. Plaintiffs have option purchased share to the extent of 1 anna out of 6 in plot number 299 and 300, and to the extent of 2 anna out of 6 in plot number 422 and 423 in execution case number 138 of 40. This suit does not lie with respect to those shares of the plots. The khewat number 79, 81 and 82 are liable to be auction sold.
In execution of
Execution of the personal decree which the plaintiff. So khewat number 79 and 82 are not part of this suit property.
81
Only
is
two-
also not there.
81 is only
there, not
two
only
plots.
three plots.
Three plots in 81 is there. Only 3 plots. And therefore, also they have to connect it what they have done. The sales certificate will speak for themselves. All those stories that they have sold, they purchased their personal property. They have to show which personal property they have purchased.
That matching is very important.
I'll match.
They will also give a chart, what is the
Yes.
description of the property and what is the property involved.
Yes,
We have already
only
given
through
this
this
document.
judgment
I'll
of
again-
1940 is the only document which will show that which property was auctioned. So otherwise, sales certificates are vague. But still, he has recorded a finding. That finding only if we accept, I'll give the chart. We have prepared it. Given again.
So what would ultimately have the effect of the subsequent rent assessment cases? So that was a proceeding where entire rent assessment case, the polls were treated to be ex interne. Not a single case where they were treated as ex interne. They did not, no rent assessment cases were. They filed also, then also the ultimate orders were passed in our favor.
And
And
ultimately the state had passed the order in your favor.
They are still under. They have also challenged that was cancelled. They are in rate application before the cycle.
so that was affirmed by the order of the water. Yes, exactly.
So
I
rent assessment
had
order
already
has been
said.
cancelled.
Yes.
had already said that with regard to 3 portions, although they were in RM form, those were excluded from our Jamabandi.
That order is also under challenge.
No,
That exclusion
No,
is under challenge.
no,
The
every,
rate is pending here. So
Which rate?
He should not. One rate of 2000.
बताइए.
no, वो नहीं है, वो दूसरा है. What is there?
Give the details.
One, with regard to the order, final order passed in miscellaneous case number 5 of 2008. The appellant, that means Karam Yogi, they had filed, which they withdrew. We had also filed, but we withdrew. And the writ petition which he is saying is some other writ petition in which we are seeking for whatever is there offline registered to, that must be made online. That is our plan.
That has nothing to do with
No, with respect to these properties only, and the state has taken a stand over because I was coincidentally in the court when my learned friend was arguing that matter.
I'll
केस का नंबर भी तो
हाँ
बताइए.
बता देंगे सब बता देंगे I must disclose it.
The state has said that those documents are false in that case also.
The recent Khatyan lordship which has been already been prepared, several plots lordship which they are now claiming, other than lordship which has been purchased by the Ashrafi, several other plots are also there which are recorded as the state's property. और हमारा जो नहीं था हुजूर, हमने तो उस पे अप्लाई करके हमारे नाम पे करवा लिया. Against that lordship they have not. I'll address it. Other plots are there in the recent Khatyan which is still in the state's property, that is more than 20 acres of land.
They will also have to
So,
disclose
so
what they
your
have considered on
the
three things.
ultimate outcome would be that all my
बात
जमाबंदी
बताइए. ये जो
हम
6 आना जो है कहानी,
हाँ
तो बाकी का 16 minus 6 10 आना क्या हुआ?
वो हम इसी के लिए बोल रहे हैं कि वो इतना ही क्लियर हमको करना है ना कि वो खेवट जो भी खेवट था, खेवट वर द प्रॉपर्टीज ऑफ जमींदार विच मेंशन्ड स्पेसिफिक खाता नंबर्स. It mentioned khata numbers, and khata number in turn mentions the plot numbers. So if in my own khewat, so that khata number has been mentioned and corresponding the plot numbers have been mentioned. So that total constitutes the 600. So if it is
That
said
total constitutes 6 annas.
6
And what
annas.
about remaining 10 annas?
The 10 owners, they were identified properties of separate person. Those are not included in these properties. So I have to only show that those were identifiable properties. And your lordship, let us assume their entire argument that it was even vague. If it was vague, then how would I be put in possession of a specific property?
They say that it was all paper transaction.
There is no document that they are.
Therefore, they say that
This is what their statement is in response to this. आपका हो गया, अब आपको थोड़ा बाकी है अभी आप.
थोड़ा सा
आप कल कंक्लूड करेंगे. कल आप लोग आइए में भी सारा बहस करेंगे.
कल उस आइए मत करिए, कल थोड़ा
आइए के लिए एक दिन रखते हैं,
एक दिन अलग से करो.
कल इसे
आप tomorrow आइए कल.
आइए आप लोग का करेंगे जब आप लोग अपना रिटन सबमिशंस करेंगे.
ठीक है, बीच में कल
तब हम आइए इसमें,
ठीक है.
क्योंकि उससे पूरा पिक्चर क्लियर हो जाएगा.
जी.
Once I get you written submissions, कल आप अपना आर्गुमेंट कंक्लूड करके, ठीक है, उसके बाद we post it for your written submissions and for further hearing on the interlocutory applications which are pending. आइए का हम अलग से सुनवाई करेंगे. जिन केसेस में आइए का सर्टिफाइड कॉपी नहीं लगा हुआ है साहब,
That will not mix.
अगर फोटो कॉपी लगा हुआ है we will not accept. This is I am very very clear.
That
आपको
will not
आइए
be
एडिशनल एविडेंस में आपका सर्टिफाइड कॉपी ही रिकॉर्ड पे लाना
That is as per
पड़ेगा.
evidence.
You cannot just put photocopy.
फोटोकॉपी, बट your lordship,
कैसे हम फोटोकॉपी
नहीं
को
वो
कैसे
नहीं, वो
हम
नहीं,
करें?
फोटोकॉपी कभी नहीं. But your lordship has to grant leave, then only that once your lordship
नहीं,
grants
leave
leave,
में-
then we can file the original or the certified.
ऐसे कोई लीव बोल के तो नहीं,
अच्छा,
आप
ठीक है.
सीधे आप फाइल कर दिए
ठीक है,
हैं
ठीक है,
एज
ठीक है.
एडिशनल एविडेंस. और इनका तो डॉक्यूमेंट्स आया हुआ, उसके ऊपर कोई आपको विशेष ऑब्जेक्शन है? जो
ऑब्जेक्शन
documents
हम
file
यही दे
किए
रहे
हैं।
हैं, यही दे रहे हैं कि उसको तो वो that in fact proves my case.
अच्छा तो ठीक है, तो यू शुड से दैट यू हैव नो ऑब्जेक्शन.
लेकिन I objected to it, but वो मेरा हम उसी से दिखा देंगे कि वो उसमें प्रॉपर्टीज क्लियर.
लेकिन आप लोग आपका जो भी सर्टिफाइड कॉपी अगर रिकॉर्ड में नहीं है तो हम कैसे उसको टेक अप करेंगे?
ठीक है.
जो भी आप फोटोकॉपी फाइल किए हैं, कम से कम रिकॉर्ड पे सर्टिफाइड कॉपी तो आपको फाइल करना पड़ेगा ना. मे बी इन द फॉर्म ऑफ ए लिस्ट ऑफ डॉक्यूमेंट्स बिकॉज फोटोकॉपी हैज ऑलरेडी बीन फाइल्ड. बट अगर सर्टिफाइड कॉपी रिकॉर्ड पे नहीं आएगा तो हम एकदम नहीं कर सकते
ठीक
आपका एडिशन.
ठीक. और ये जो काउंटर ये लोग
आपको जो जो फाइल करना है आपको
नहीं वही एडिशनल एविडेंस हम
क्योंकि देखिए हम किसी को
Counter.
ये बोल के नहीं रोकना चाहते हैं कि अभी कर रहे हैं, फिर अननेसेसरी दैट क्रिएट्स अ प्रॉब्लम. जिसको भी जो फाइल करना है सबको ले देकर ऑर्डर करें.
ठीक
किसी को छोड़कर ऑर्डर दें.
ठीक ठीक.
इसीलिए ये ग्रीवांस नहीं होना चाहिए कि मेरा ये डॉक्यूमेंट नहीं गया. दैट बिकम्स अननेसेसरी. अगर है कोई सर्टिफाइड कॉपी देख लेते हैं क्या है क्या नहीं है. बेसिकली आपको जो प्रोविजन ऑफ लॉ है यू हैव टू सैटिस्फाई दैट. And then I have to see whether I am able to pronounce a judgment without that document. If you have not produced it earlier and you don't have a proper explanation for that, then I have to see whether I need those documents to pronounce a judgment. यही तो है, law तो यही है ना.
हाँ.
बस इतना ही है. ठीक है, post tomorrow for further arguments. आप लोग अपना टाइमलाइन दे देंगे कि आप लोग कब तक जमा करेंगे, क्योंकि अगर आप उस दिन तक नहीं जमा करेंगे देन आई विल नॉट एक्सेप्ट.
कल के बाद
कल के बाद एडजर्न करेंगे हम, कम से कम
रख दिया जाएगा तो
कल के बाद हम मंडे को कर देंगे.
Yes,
इस बीच हम लोग
then wait.
आप फ्राइडे तक दे दीजिए.
जी.
वीकेंड हमको भी चाहिए पढ़ने के लिए.
जी.
ठीक है, आप लोग का सब पढ़ेंगे समझेंगे, हम भी अपना जजमेंट लिखना शुरू करेंगे कम से
तो
कम।
वो ट्यूसडे को रख दिया जाए कि हम लोग
नहीं मंडे को क्यों, आपको क्या लगता है आप यहाँ पे 5 बजे फाइल करेंगे, हम रात भर बैठ के पढ़ेंगे फिर?
वीकेंड्स बनाने में हम लोग
वीकेंड नहीं बनाना, आप बनाइए, आपको बोल रहे हैं आप
ठीक है।
काम ऑलरेडी चालू कर चुके हैं,
ठीक है, चलिए
है ना, आप लोग किए हुए हैं ना काम, ऐसा नहीं करिए, फ्राइडे तक जमा करेंगे तब सैटरडे संडे।
ठीक है, tomorrow is Tuesday, हो जाएगा।
आई ऑल्सो नीड टाइम ना, उसके बाद जिस दिन आइए आपका करेंगे उस दिन हम करेंगे, हमको जो क्वेश्चंस होगा कुछ, अगर आपका देखिए प्लेंटिव्स की तरफ से बहुत बड़ा हर्डल है आइडेंटिफिकेशन ऑफ प्रॉपर्टी, दिस इज अ ह्यूज हर्डल व्हिच यू हैव टू क्रॉस।
ठीक है, ठीक है।
इसीलिए आपको जहाँ जहाँ डॉक्यूमेंट्स में दिख रहा है वो, और
हम
आप
सब कर रहे हैं, हम सब कर रहे हैं।
क्योंकि
But
इनका
ये
ये
मुझे-
कहना तो
हम-
सही है ना कि प्लेंटिव को तो अपना केस खुद प्रूव करना होता
100%,
है,
100%।
इसमें तो कोई डाउट
हम
नहीं है।
उसका ये नहीं कर
अगर
रहे हैं।
प्लेंटिव का प्रॉपर्टी वेग रहेगा तो बहुत दिक्कत है,
हाँ,
कोई भी डिग्री कर,
लेकिन यहाँ पर डिग्री इज ऑलरेडी देयर, दे हैव चैलेंज, तो यहाँ पर होगा क्या, ये दिस हैज टू बी अंडरस्टूड।
That's right.
It
You
is
can
a
see that.
litigation between two of us. Here I am not talking anything about the state or third parties, whatever. Here it is a litigation between two of us,
That's right.
two sets of parties. So our basic litigation would be only guided first. Essential stone is that we have to be bound by our pleading. So
That's right.
if in my pleading they have not disputed, so can they now at this stage challenge that the suit property
ये
was
जो
not
अदर प्रॉपर्टीज
identified?
का जो बात है, अदर प्रॉपर्टीज
हाँ,
का जो
ठीक है,
बात है,
हम
देयर
उसी-
हैज बीन सम लैंड एक्विजिशन प्रोसीडिंग, तो अदर प्रॉपर्टी तो दिख ही रहा है,
नहीं वही है, those
उसी का ही पार्ट
उसका
है।
तो लाए नहीं ना, उसका what was the basis for giving payment to them, they have not brought. So the basis was 80 to 83, rent was assessed in their name, then ultimately when it was cost between that this is of the year 2003-4. So therefore the moment they rely on exhibit G, which is payment of compensation, they were required to bring the order by which they had been paid compensation. They cannot just bring some random document showing that I have been paid compensation with regard to the
because there is an intervening situation.
Yes. So, Your Lordship, the essential proceeding would be according to the proceedings which have taken place after vesting. Those two proceedings, in both the proceedings, have been considered to be ex-intermediate, and those proceedings have attained finality. They have to be taken note of, and those
They
proceedings.
say that in one of the proceedings it has been said that your M forms are also doubtful.
Also doubtful.
That is DC's order.
Therefore, entire order of the Deputy Commissioner has to be seen, not a single line of the Deputy Commissioner.
single line.
When he said doubtful, then because he mentioned specifically that Rasta or Sairat का भी जमाबंदी खोल दिया गया है, which that 631, 632 removed.
Excluded lordship
So
of the appellate court judgment.
and
Not
ultimately
the
what he did was he restored all the jamabandi in our favor. So what is the ultimate effect? That all the jamabandis right from 49, 51, 52, 54, 55, all those jamabandis he restores except the portion which he directed to be removed. That
And you have to also, you see, there are so many orders which may be relevant, right? So you have to also point out in particular which all orders are to be incorporated in my final judgment. I will also see to it.
interlocutory orders.
Yes, we do not know, there are so many interlocutory orders, if anything is relevant for the purposes of final disposal. Right?
Yes.
That also we have to take care of. Right? वो तो उनका तो हो गया, प्राइवेट रिस्पॉन्डेंट जो भी हैं,
वो तो खत्म हो
वो तो कहानी खत्म हो गया, उसमें तो ज़्यादा कुछ है कि नहीं, और उसमें जो भी है वो ऑर्डर हम लोग नोट कर लिए कौन सा
ठीक।
ऑर्डर, उसके अलावा कोई ऐसा चीज़ नहीं होना चाहिए। सुप्रीम कोर्ट ने तो इसी ग्राउंड पे रिमाइंड किया था कि इंटेलेक्चुअल एप्लीकेशन कुछ कंसिडर नहीं हुआ था प्राइमरीली, विद स्टेट का
Because state was impleaded
हाँ।
at appellate stage.
हाँ,
And it
एंड दे
was-
सेड कि हमारा कैसे राइट डिसाइड होगा,
This was the ground.
दिस वाज द
So amongst ourselves, nothing was finalized.
nothing was finalized. और जितने भी इंटेलेक्चुअल एप्लीकेशंस पेंडिंग थे जो भी वो सब रिवाइव कर गए.
Only those pending on the date of the judgment,
That's right. Only those
which
pending.
which was
अभी
disposed of.
इसके अलावा तो कोई एडिशनल एविडेंस के आईए के अलावा तो कोई इंटेलेक्चुअल एप्लीकेशन किसी का सब्स्टिट्यूशन ये सब तो कुछ पेंडिंग नहीं है,
नहीं.
है ना?